Just a couple comments. I mean, I don't think there's no secret that I've been critical and opposed to this proposal of the block granting of human services since it was first proposed last year, and I'm not going to go over the reasons why. I just quite simply just don't think that you should be pitting these individuals, these poor people, against one another for what appears to be a dwindling source of revenue. Unfortunately, I asked DPW to come here and defend why they wanted a block grant and explain how it's working. I understand they're in some type of transition with some of the the appointments in DPW, but I just would be remiss to say that I'm really disappointed that they chose not to come and be here today. I mean, this is a major historic shift in the way that we fund human services. And also, unfortunately, there are proposals out there presently to expand what's supposed to be a 20-county pilot. And I'll underline the word pilot program. Over in the Senate, they circulated a co-sponsorship memo that would expand it to any county that wants to get in. There's another bill over here in the House that would expand it by 10 counties. This block grant has just been up and running and live since the end of January. I've been trying to get information on where the money has been moved in the 20 counties in the pilot program, and I have not been able to get that information yet from DPW. Now, I know there's reporting in there, and there's a report due to the General Assembly later in the year, but geez, don't you think before we start talking about expanding this, that we should have some type of evaluation on whether it's working or how it's working? Or, I mean, a pilot program to me suggests just that, a pilot program, that at some point in time, whether it be a year or 2 years down the road, you evaluate it, see how it's working before you try to expand it. I don't know. That's the reason I'm calling this hearing today. I just want to try to see where everybody, and I tried to make it balanced. I invited DPW. We're going to hear first from the County Commissioners Association. I really appreciate them for being here today. I really do. And then we're going to hear from some other people around the state on, what they're seeing or what they're thinking. We have with us today Greg Heller and also Mark Murphy, who's the Executive Officer for the Disability Rights Network of Pennsylvania. Appreciate both of you gentlemen being here today. Running a little bit behind, but that's okay. I think we have the room till 12, so whenever you're ready, Greg, I think you're first. You can begin.
I want to talk about county liability and the liability that is out there under the pilot block grant program. There are two kinds of reasons why counties are on the hook in ways that they weren't before the block grant. And the first set of reasons are what I'll call structural reasons. In other words, they arise simply out of the fact that these decisions are now being pushed down to the counties. And because they're structural, they don't turn on what any particular law says, either state law or federal law. They're just part of the furniture now. Now, the first principle is a simple one, but it bears repeating. Liability goes with responsibility. Again and again and again, over centuries, responsibility ends up with somebody that didn't exist before. Eventually, liability catches up with that, and it should. It used to be, for example, in Pennsylvania, you could not sue a hospital. You could sue a doctor, but not a hospital, because that's just a building with a roof where doctors practice medicine. As the world changed, as hospitals took on these greater responsibilities, integrating services, etc., the law caught up with that. As counties take on these new roles and responsibilities, it's a certainty that the law is going to catch up with that. Now, the second reason has to do with the United States Constitution. Under the 11th Amendment, federal laws, and you're going to hear about some of this in a minute, a claim for violations of federal laws against a state can't get you compensatory damages, money damages, punitive damages. A federal court can award injunctive relief and prospective relief, but it's not going to generate a fund of money either for the victim or, frankly, and this is my day, this is what I do for a living, or for contingency fee lawyers. Counties don't have that liability, that immunity. They do have the liability. They don't have the immunity, and nobody can give it to them because it's there in the federal Constitution. So what the pilot block grant does is take all these decisions out of the hands of somebody who really can never be forced to write a large backward-looking check for it and give it to somebody who can be. Now, let's just think about that dynamic for a little second. The Disability Rights Network and a lot of other organizations have done unbelievable work over the years enforcing rights, protecting the disabled, advancing the cause. But there has never before been an incentive for the kind of cash recovery that would get the trial lawyer's contingency fee bar interested. That changes when these decisions go down to the counties. Now, we have also seen the burden of demonstrating compliance with federal law move to the counties. And I heard from Representative Baker a reference to a DPW analysis. And I want to say just a couple things about that. First, we also learned today that the reporting is all post. The DPW analysis, if it's the one that was publicly available that I'm aware of, and I'm sure it is, says, oh, well, DPW is going to sign off on this. Well, the reporting is all post. So the notion that DPW, number one, would comprehensively sign off on it and give everybody sort of a different kind of immunity, a guarantee that it's right, when we learned today they're not even going to have the data until after the fiscal year is closed in terms of what funds are being used, is, well, it wouldn't give me any comfort if I had to go face the taxpayers in my county, I'll tell you that. Now, the compliance burdens, you have all these federal laws, that the pilot block grant explicitly imposes, and this is sort of a little bit structural, a little bit statutory, explicitly imposes on counties, because it says counties now have these duties. And I just want to offer a couple of quick comments on that. Number one, the room that Deb described, where the disabled had to fight for their space on the blackboard. I understand, and Deb, am I right about this? There was not a single county elected official in that room. These are the county officials that now say, trust us, we're going to mind the store with these new duties under the pilot block grant. And the second point is another example I heard, or I thought I heard, a reference to innovative programs that we can do for the disabled, like we can do genetic testing on everybody and identify people ahead of time. Now, people in counties, anyone, we're all allowed and entitled to think innovatively, but there's a federal law called the Genetic Information Non-Disclosure Act that may well have a lot to say about that kind of testing. And the suggestion that there are 67 county solicitors that are eager to vet proposals against these complicated federal requirements, which may well be, frankly, unknown to city solicitors, I think that suggestion's a little aggressive. There are specific statutory grounds for liability that will arise now, and Mr. Murphy's really going to talk about really the main ones, the Americans with Disabilities Act and the Rehabilitation Act claims. I'll just note that they're substantial, and while they're under the current regime, there's no pot of money, as I mentioned. There are attorney's fee awards, and they can number into the hundreds of thousands of dollars. And again, if you're in a county with a few tens of thousands of people, the notion of going to the voters and saying, look, the federal court says we have to pay $400,000 in lawyers' fees is not something I imagine. I can't understand why elected county officials look forward to that. We have the Mental Health Parity Act, that is increasingly part of the law. It's sort of rolled into the Affordable Care Act. The Affordable Care Act is coming online. We have maintenance of effort requirements in the Affordable Care Act. I am aware that DPW has suggested, oh, well, that's not a problem here. They're wrong. We heard today, and we're getting increasing evidence of Act 152 funds that are being lost either in part or in whole, and eventually they'll be able to move 100%. Act 152 is a method by which people access medical assistance. It's one of the ways to get there. And under the Affordable Care Act, a state is not allowed to change a method of eligibility, a method of accessing medical assistance. To suggest that we can remove a method of access and then guarantee 67 counties that that's not a maintenance of effort problem, or frankly, even guarantee Pennsylvania, that doesn't make a lot of sense. I have heard, and I'm sure you're going to hear, well, nobody's been sued yet. You know, there was a day at Merck when people could walk into work and they could sit down and say, you know what, we haven't been sued yet for Vioxx. That was true when it was true. It wasn't a problem until it was a problem. So we need to be careful we don't take too much comfort from that. Look at what's starting to happen even now. Today we heard about significant sums in Dauphin County moved from children and youth at a level of clarity previously hard to come by at best, if it was available at all. People who are getting turned down for services they used to get are going to notice the difference. I'm an optimist. I believe the transparency is going to come even to the pilot block grant eventually. I think when that happens, people are going to be able to see what's causing these changes, and we're going to get more concrete guidance out of the administration, sort of by hook or by crook. I won't say too much about that, but there's an effort in the courts directly addressing the lack of concrete criteria and other forms of formal guidance. And when those things arrive, they will be tested, and they'll be tested by passionate, highly skilled advocates. My last point, I think what we've heard again and again has boiled down to trust me. The counties have been told by DPW, trust me. The various interest groups have been told, trust me. And that is no substitute for careful analysis, for stopping and waiting and seeing what has happened and how things are shaking out, for looking at the data, and for responsibly moving on such a sea change in such an important part of how the government does its business.
Greg, thank you. Mark?
Thank you, Chairman DiGirolamo, and thank you for the opportunity to testify today. My name is Mark Murphy, and I'm the Chief Executive Officer of the Disability Rights Network of Pennsylvania. DRN is a statewide nonprofit organization that advocates on behalf of people with disabilities and their families. The enactment of the block grant last year significantly changed the responsibilities and obligations imposed on the Commonwealth and the counties by the Mental Health and Intellectual Disability Act of 1966. Now, nearly a year later, the arguments that DRN made in opposition to the block grant remain valid. Most importantly, as you've already heard today, particularly with the last panel, the legislation has already caused the loss of critical services for people with disabilities, including residential services. What has gotten much less attention, however, is that the block grant law will expose the counties to significant legal liability that they would have largely avoided under the former system as authorized by the MH&ID Act. And I'd just like to devote the remainder of my comments to that second point. Both the Americans with Disabilities Act and the Rehabilitation Act, which are federal laws, impose what's called the integration mandate. And what that does is require public entities such as counties to provide services to people with disabilities in the most integrated settings appropriate to meet their needs. In the landmark case of Olmstead versus LC, the United States Supreme Court interpreted the integration mandate to prohibit the unnecessary institutionalization and segregation of people with disabilities. And in the years since Olmstead, which is 1999, federal courts have found the Commonwealth to have violated the integration mandate by unnecessarily segregating individuals with mental illness and intellectual disabilities rather than providing them with community services. The integration mandate also applies to government policies and practices that simply place individuals at risk of institutionalization or unnecessary segregation, as well as to government policies and practices that result in the provision of unnecessarily segregated services, even outside of institutional settings. So the block grant legislation exposes the counties to liability because it substantially shifts responsibility from the Commonwealth to the county to decide how the funds will be spent to serve people with disabilities, and it reduces the amount of available funding to provide necessary services to these individuals, as we've heard a lot about this morning. If the counties, as is permitted by the block grant law, shift funding, for example, from MH and ID services, as is inevitably the case since that's 90% of the block grant, to human services, to programs for people without disabilities, job training for low-income adults, programs for older adults, dependent delinquent children, then individuals with disabilities will lose services or not have access to services. As we know from long experience, this will place these individuals at high risk of placement in more segregated settings, inpatient psychiatric hospitals, state institutions, prison, and jails in violation of the integration mandate. This is not, as you've already heard today, again, a hypothetical scenario. Already this year, counties have closed residential programs for people with mental illness and otherwise reduced housing and other supports. In addition, DRN's aware that the counties in at least one service area have reinstitutionalized some individuals and are considering reinstitutionalizing other individuals who've been discharged from a state hospital that had previously been closed. And this is happening because the counties are unable to maintain the necessary funding to continue serving these individuals. This is in part the CHIP problem you heard about from the last panel, the idea that money was provided, then it was cut, there's just not enough money, even though those promises were made. Until now, as we've heard, DPW has borne statewide responsibility to ensure compliance with federal law that people are being served in the most integrated setting. With the block grant, however, that shifts the decision for allocation of funds to the county level, and as a consequence, shift the burden to ensure legal compliance to the participating counties. Counties that reinstitutionalize or otherwise segregate individuals rather than use all available block grant funds for the community services that these individuals need in the most integrated setting are at serious risk of being found in violation of the ADA and the Rehabilitation Act. Last year, and continuing since the time when the discussions have occurred around the block grant, DPW has downplayed the risk of county liability, perhaps not surprisingly. They've talked about how the block grant's a partnership, that they're not aware of any lawsuits, as Greg said, it doesn't create entitlements, and that the counties are required to submit a block grant plan that will prevent any liability from attaching. Each of these arguments is legally flawed, and I talk about the reasons for that in more detail in the prepared testimony that I've provided to the committee, so I won't go into detail now in the interest of time. But those arguments, we believe, are seriously flawed, and the county should take no comfort from them. DPW telling the counties that their block grant plans will shield them from liability under the ADA and the Rehabilitation Act is particularly ironic, given DPW's own failure to create Olmstead plans that comply with federal law and limit their own liability. They've been found liable by the courts themselves. And then finally, just to reiterate something that Greg said, the fiscal impact on counties in defending against legal claims that they have not previously had to face likely will be significant. Defending against these claims obviously would require lawyer time, monetary resources, whether they use their own lawyers or have to hire lawyers, their expert fees, and then, as Greg also pointed out, the payment of substantial attorney's fees to successful litigants. The Commonwealth obviously is better able to absorb these costs. Perhaps even more significantly, the counties are exposed to claims for monetary damages in ways that the state were not, for the reasons that Greg said. And this is really a big issue that I think the county has not been seriously considering what that means. So When you don't provide necessary services to people with disabilities, they're driven into higher cost services. They end up in segregated alternatives such as psychiatric hospitals, state institutions, emergency rooms, hospitals, and jails. And as we've talked about this morning, these outcomes have already started to happen, and this in turn is going to lead to liability for counties under the integration mandate. In sum, the block grant program is essentially a Trojan horse. It clearly exposes counties to significant liability that they would have largely avoided under the former system as authorized by the MH and ID Act. And I think this is something that the counties need to be better aware of. It's not clear that they were aware of. It's pretty obvious to me why the state's perfectly happy to shift that legal liability to the counties. And as again, I say, it's the analogy I came up with, it really sounds very much like a Trojan horse where they say, here's your block grant, here's your flexibility. In addition to all the other problems with it, what's less talked about is what the county has purchased with this is basically a lot of legal liability they wouldn't otherwise have had. Thanks for the opportunity to be here this morning.
Thank you both. And I have just a couple quick questions. If, I'm looking at Commissioner McIntyre, if I was a county commissioner and was trying to make a decision on whether to be a block grant county or not, I would assume, to protect myself and my county and my taxpayers, that I would ask DPW for some type of letter, assurance, something on the issue of liability. To your best knowledge, was any letter ever issued by DPW absolving the counties from liability if they decided to opt into the block grant, Greg?
I mean, two things. Number one, you would expect not only a letter, but I don't know why DPW wouldn't put their money where their mouth is and essentially indemnify. Now, that might require statutory action. Would say, hey, look, if we approve a plan, maybe when we get the numbers in the future and go back to the past, in any event, if they approve a plan and it ends up costing you money, we'll make good on that. I haven't heard that. Even on the much more limited notion of a letter, the one document that I am aware of, and I think it's the only document that's out there, I haven't seen it before, and I've been out of law school for a little while. There is nobody's name on it. It's not signed. There's nobody's name attached to it. Nobody has said, this is my professional opinion, that this is the way these things are going to shake out. It's remarkable and frankly speaks volumes.
Hypothetical situation. I'm a non-block grant county. A family calls for help for their son or daughter who has a drug problem. The county is at a point in the fiscal year, point in the month, where they don't have any money available at the present time, and this individual, son or daughter, is put on a waiting list. In the worst case scenario, where tragically, while this person's on a waiting list, the individual is involved in a drug overdose and passes away. Would the county that's not part of the block grant be liable to be sued because that person was put on the waiting list because of lack of funding?
No.
I feel like I'm in law school again.
Changing that same scenario around, and they are a block grant county.
Right.
And let's say, for instance, the county, who's a part of the block grant, moved 152 or part of their BHSI money around to a different category, or did not leave it in residential rehab but moved it to medicated assistant treatment. And this same individual was put on a waiting list and tragically and unfortunately died of a drug overdose. Does the county in that instance potentially put themselves liable for a lawsuit?
Let me answer that a little bit differently. I would take that case, and I suspect that some of my Philadelphia trial lawyer colleagues would leap at the chance to take a case like that.
I think the important thing to remember is if you're making the decision, you're buying the liability. Greg may win that case, he may not win that case, but you're buying the cost to defend it, you're buying the liability if he does win the case. And the whole point of this is that previously it was DPW who was making decisions about, the county would go to DPW, certainly in the mental health and intellectual disability context, would go to DPW and say, we want to serve more people, and DPW would say, we don't have the money, we can't give it to you. It was their decision. That would be a valid decision or an invalid decision, but DPW was making the decision. Now, DPW is giving the county all the money and saying, you make the decision. And when you make the decisions, you buy the liability that goes with making the wrong decision. And they just didn't have that previously, and now they do.
Representative Painter.
I'm sorry, I can't resist the law school thing. I'd like to follow up on the chairman's question and ask one more. The same scenario that the chairman was describing, it's May, it's late in the budget year. We have a person who's in crisis and needs drug and alcohol services in a block grant county. The chairman's scenario was the county's moved some of that money into a different category. What if the scenario is the county refuses to move money into that category? Say move money from intellectual disability services into the drug and alcohol category, and this person ends up on a wait list because of the county commissioner's refusal to move money into that program from another source, and then tragedy follows.
I'm just not sure. You're saying, in other words, this is somebody who needs what, the drug and alcohol services?
Right. So a person who's in crisis. It's late in the budget year. I'm following up on the chairman's scenario, but in a block grant county. But the chairman's scenario was, what if the county moved money out of drug and alcohol treatment, and that's why there's no money left there.
Right.
My question is, what if there's no money there, but the county has money in another category, say intellectual disabilities, and the county declines to move money into that program, and a tragedy ensues from lack of funds?
Well, like any good law school question, that kind of move, it makes it harder, right? Because you're no longer talking about violating a statutory duty that causes a harm. So it's more fraught, but absolutely that's a risk. Absolutely, that county is at risk.
I also think there's a slightly different scenario. It's not. The liability I'm talking about is not necessarily liability in the event of some terrible tragedy that somebody dies or somebody hurts somebody else. I'm saying that there's clear legal liability to a county if they make decisions such as whether it's the end of a budget year or not, in which somebody, for example, with intellectual disability or mental illness, who, as a result of the decision not to provide services and spend the money somewhere else, ends up in a more segregated setting, such as an emergency room, a jail, an inpatient psychiatric facility. That's a fairly common scenario, and the potential liability there, because the county is making a conscious decision not to spend money, particularly to the extent they spend some of the block grant money on persons without disabilities, which is clearly possible under the block grant. And so the idea that as a result of spending money not on people with disabilities, and then that then drives people from integrated settings, they might be in a group home, and the next thing you know, they're in a psychiatric facility, that raises serious legal liability under the ADA, as the Supreme Court has held.
Representative DeLizio.
I would like to know what a CCAP's response is to this immunity issue from CCAP. What was the county commissioners, what were they told? Was this question even raised by the County Commissioners Association? If there's a position statement out there that you support block grants, and this is indeed an issue, a concern, then this issue also, from a policy standpoint, should have been addressed. So what was the discussion from the county commissioners on this issue? What decision has been reached about this, whether or not they have immunity? What definitive information is available?
I would love to know what they were told. I can't believe they moved forward without talking to a lawyer about it, and the fact that there is no clear answer to your question that I know of.
Well, that's why actually, Greg, I'm directing it. I'm looking right at Brenda.
Yeah,
so I anticipate that subsequently,
Thank you.
For putting you on the spot, you're welcome.
Not putting me on the spot at all, honestly. CCAP hired counsel who reviewed all of the issues related to the block grant. That counsel then shared his opinion with the solicitors who, at the county level, were in contact with him as counties contemplated what they planned to do. And that is how we handled those questions. There may have been questions in those discussions beyond even the questions that have been discussed here. We didn't get directly involved in that. We employed counsel so that counties would have someone with expertise that their solicitors could direct questions to.
So then, short of asking your association for that opinion in those documents, I guess it's the open records route to identify that information. I'd be curious as to exactly what that opinion was, and gave that, obviously must have given some level of comfort to counties to move forward on this. This is not an insignificant issue. And as both these lawyers have said, even when you're right, you end up defending yourselves, and that costs money.
Correct.
Brenda, do you mind if I just, and again, I hate to put you on the spot. I think I know who the individual was that you hired to give your opinion. Was he willing to sign a document giving his opinion? Was he willing to sign a letter? Is there a signed letter from the attorney that you hired on the liability issue?
That's not what we asked him to do. We asked him to share his opinion with solicitors who reached out to him to have those discussions. If there was something shared individually with the county, that would be between him and that county. Okay.
Okay. Else? Okay. With that, Brenda, thank you again for being here. Mark, Greg, always good to see
Thank
you.
you, Mr.
Thank you
Chairman.
for your testimony today, and to everybody that's out there, wherever you're from. I mean, I know there's some people that's traveled a long distance, and I know I really appreciate you being here today and listening this testimony. And let's see what happens as we move forward. I mean, again. I just don't like block granting of human services. I would like to see the whole thing go away. But we do have this 20-county pilot block program in place. But boy, let's take a look at how it's working, and let's evaluate it first. Let's get some reporting in before we even talk about expanding it. I mean, I just think that's the responsible thing to do. And that's where I'm coming from. And again, thank everybody for being here, the staff and representatives, and